What's up, everybody? Grand Rising. So I was reading the Rourke and Phelps on equity document, and he has a little spot in here talking about Gibson's suits at Chancery, sections 21 through 24, exclusive equity. So I'm going to try to read through that, and it's only 4 or 5 pages. So let's see if we can do it. Here's Gibson suits at Chancery. This is page 20, jurisdiction of the Chancery Court. I'm going to try to get through 25. So let's start with statutory changes in the powers and jurisdiction of the court. As it has already been stated, the statutory changes in the powers and jurisdiction of the Chancery Court have mainly been additions and not limitations. Jurisdiction means the authority possessed by a court to determine a controversy, and the powers of the court are its right and ability to enforce its determinations. The principal additions to the powers of the court are the following, given in order of time. Power to order a bill to be taken for confessed, number 1. Number 2, power to issue an execution to enforce a money decree. Number 3, power to bring defendants before the court by publication. Number 4, power to divest and vest title to property by decree. Number 5, power to issue attachments to impound property. Number 6, power to appoint a commissioner to execute a conveyance, release, or acquittance in the name of either the parties or of himself. Number 7, power to appoint administrators ad litem when necessary in the progress of a cause. All right, this is 2, subsection 2, subsection 20, section 2. The principal additions to the jurisdiction of the court are the following, given in chronological order. Jurisdiction to impanel a jury to try and jurisdiction to impanel a jury to try an issue of fact. Number 2, jurisdiction to proceed against non-resident and absconding defendants by publication. Number 3, jurisdiction to decree a divorce and alimony. Hey, quiet down. I'm trying to do a recording here. All right. Number 4, jurisdiction to proceed in rem against the estates of non-residents by attachment and publication. Number 5, jurisdiction to proceed against the real and personal property of non-resident defendants. Number 6, jurisdiction to proceed by attachment and publication against the estates and persons of non-resident absconding debtors. Number 7, jurisdiction to appoint an administrator and wind up his intestate's estate. Jurisdiction to keep corporations in the line of their duties and to decree a forfeiture of their charters. Number 9, jurisdiction over the persons and estates of idiots, lunatics, and persons of unsound mind. Joe Biden. Number 10, jurisdiction to consent to and decree a sale of the property of infants and married women. If the courts had inherent jurisdiction to do this, the statute certainly settled all debts and enlarged that jurisdiction. Number 11, jurisdiction to prevent the usurpation of office and to declare an office forfeited. Number 12, jurisdiction of all civil causes of action triable in the circuit court except for injuries to persons, property, or character involving unliquidated damages. 21, subsection 21. Effect of the Act of 1877 generally considered. In 1801, it was enacted that after answer filed and no plea in abatement to the local jurisdiction of the court, no exception for want of jurisdiction shall ever afterwards be made. If it has been formally held ever since the passage of this act that on failure of the defendant to object to the jurisdiction of the court before answering, the court had the right and it was its duty to determine the controversy unless the matter was unfit for the court of equity. Under the operation of this holding, the Chancery Court had, for 75 years, been in the habit of entertaining demands and causes of action purely legal in their nature. The Act of 1877 is only one step further than the law was before, as Judge Freeman in Jackson versus Nemo very conclusively shows. The Chancery Court has long had jurisdiction in attachment cases of debt or demands of a purely legal nature, except causes of action founded on torts. Thus, it will be seen the Act of 1877 is by no means as revolutionary as was at first supposed. Every enlargement of the Chancery jurisdiction for 500 years in England and America has been the signal for an alarm, but the enlargements have continued until both in England and a majority of the American states, the Chancery methods of pleading and the principles of the Chancery jurisprudence have, in a large measure, superseded the unbending formalities and the harsh doctrines of the common law. The Act of 1877 goes far to settle the ancient controversy between Chancery and the common law courts with respect to the boundary line between their respective jurisdictions. And it includes not only the disputed territory, but also all the territory adjacent thereto, within the concurrent jurisdiction of the Chancery Court. In the England Jurisdiction Act, passed in 1871, it is provided that provided that generally all matters in which there is any conflict or variance between the rule of equity, generally in all matters in which there is any conflict or variance between the rule of equity and the rules of common law with reference to the same matter, the rules of equity shall prevail. The effect of this provision is to make the rules of equity supreme in all litigation in all courts of England. It is believed that the Tennessee Act of 1877 has the same effect in all common law rights of action sought to be enforced in Chancery. When the jurisdiction of the court is enlarged, the new subjects of jurisdiction should not be treated as aliens and discriminated against, nor should the parties to such suits be held in disfavor or denied any equitable right, benefit, or privilege accorded by the court in the ordinary exercise of its jurisdiction. The Act of 1877 was manifestly intended to enlarge the jurisdiction of the Chancery Court as a court of equity, and not to make it, as to this enlargement, a mere common law court. And hence, in all suits brought under the Act of 1877, the pleadings and practice and principles of equity jurisprudence will control. All right, subsection 22. Classification of matters of equitable jurisdiction. The importance... Is he going to bark again? Hey, quiet. The importance formally attached to a proper classification of the subjects of equity jurisdiction no longer exist in this state, and it is now immaterial whether the matter in controversy is within the equitable or the statutory jurisdiction of the court. And if within the equitable, it is unimportant whether the jurisdiction be exclusive or concurrent. As a result, all of the abstruse learning in the books on the lines of demarcation between the different grounds of jurisdiction has ceased to be of much practical value. The legal necessities, the complex technicalities, and the dialectical discriminations on the subject of the jurisdiction with which the great jurists of England and America wrestled in the last 5 centuries no longer perplex either the student or the practitioner of this state. For convenience of consideration, the jurisdiction of the Chancery Court, as now constituted, may be divided into 1, the equitable or inherent, and 2, the statutory. Interesting. All right, subsection 1. Subsection 22, section 1, the equitable or inherent, to include all of the matters, whether purely equitable in their nature or having characteristics both equitable and legal, jurisdiction over which is derived exclusively or chiefly from their inherent powers as courts of equity. And 2, the statutory, to include all of those matters, whether equitable in their characteristics or purely legal in their nature, jurisdiction over which is derived exclusively or chiefly from our statutes. All right. Subsection 23, the equitable or inherent jurisdiction of the Chancery Courts. The equitable or inherent jurisdiction of the Chancery Courts generally considered. The jurisprudence and procedure of the Chancery Court constituted a part of the law our ancestors brought with them from England when they founded the colony of North Carolina. When that colony became a state, this jurisprudence was recognized. When that colony became a state, the jurisprudence was recognized, and its administration provided for in its constitution, and in 1782, its legislature conferred this jurisdiction upon the courts. Tennessee being then a part of North Carolina, that jurisprudence became a part of our land, and when we became a state, both the deed of cession and the act of admission by Congress made the laws of North Carolina our laws until we saw fit to change them. In our first and in all subsequent constitution, the jurisprudence and the procedure of the Chancery Court were fully recognized, and their administration abundantly provided for. While the procedure has been modernized, simplified, and improved in many particulars, as already fully shown, the jurisprudence has in no particular been changed except insofar that it has been extended and enlarged on the lines of its legitimate development. The original jurisdiction thus derived through the colony and the state of North Carolina from the equity jurisprudence of England is called the inherent jurisdiction of the court. The inherent jurisdiction of the court, to contradistinguish it from the statutory jurisdiction. And it is to this original and inherent jurisdiction that our statutes refer when it says the Chancery Court shall continue to have all the powers, privileges, and jurisdiction properly and rightfully incented, I can't read that word, incented? All right, you guys tell me what that word is. To the court of equity by existing laws. The inherent powers, privileges, and jurisdiction of our Chancery Courts within their respective local and personal jurisdictions are identical in kind and commensurate in extent with the equity powers, privileges, and jurisdiction of the High Court of Chancery in England. At the time of the American Revolution, the Chancery Court is the Supreme Court of general original jurisdiction of all cases of an equitable nature where the debt or demand exceeds $50, and every matter of equitable cognizance above said amount is presumed to be within its inherent jurisdiction as a court of equity. Number 24, last section. Equitable or inherent jurisdiction generally stated. The whole inherent jurisdiction of the Chancery Court, aside from its injunction powers, may be briefly summed up in these four propositions. Number 1. If a law and equitable contract be the subject matter of a suit, all the court can do is 1. To equitably enforce the contract, or 2. To award compensation for its breach, or 3. To require the party in default to do such act relative thereto as he in good reason and good conscience ought to have done without suit. If there be no, number 2, if there be no contract, or the contract be inequitable, and the parties disagree as to their rights and duties, all the court can do is 1. To require the party in default to do, or refrain from doing, what good reason or good conscience require, or 2. Whether injury has been done, to make the defendant atone thereafter. Number 3. If any of the parties are under disability, and 1. Their interest will be promoted by a sale of their property, or by a conversion of their money into their property, or by using a portion or all the corpus of their estate for their maintenance, education, or support, or 2. If their rights need protection or enforcement on the application of a guardian or next friend, the court will, 1. By decree do that for them what they in reason and conscience would do themselves have done if under no disability, or 2. Will require the parties who are sui juris to do it to do to or for those under disability what in good reason and good conscience they should have done without suit. Number 4. If the parties are sui juris, whatever they consent to during the progress of the suit will, if violative of no law, be binding in the court, and if it is to the interest of an infant or lunatic party to join in any lawful consent, and the state of the pleadings permit, the court can consent for such infant or lunatic. And generally, where there is consent, the parties bind the court, and where there is no consent, the court binds the parties.